All right, hello again. This is Ben Hitchcock Cross talking. We are going to do a short one, just really on research here. I'm going to go to, all right, what we have before your very eyes is the state of Wisconsin's fair employment law. It's the drafted one, I think it's from 2017 is the latest one. I don't know why, but we are going to go back in time here and see what the difference is. So this is the law, the sort of declaration of policy that we were going through, here. And what I want to show you, I guess, is two parts. This is the law itself, the actual statute. It's not necessarily binding as we went over for there, but let's see. Practice of unfair discrimination employment is against properly qualified individuals for unlawful reasons. Ooh, it's expanded here. Look now, age, race, creed, color, disability, marital status, sex, national origin, ancestry, sexual orientation, arrest record, conviction record, military service, use or non-use of lawful products off the employer's premises during non-working hours, or declining to attend a meeting or to participate in a communication about religious matters or political matters substantially and adversely affects the general welfare of the state. Bam. That is the statement there now. Okay. Here we go. Same as before, all they do that, declining to attend, deprive those individuals of the earnings that are necessary to maintain a just and decent standard of living. Let me highlight that. It's not because it's a web page. Okay. Now, let's go down here. This section right here, this first history is what we're going to look to. But this section right here is called the annotations. So somebody at the state took basically what they thought were legal cases that are the law, meaning appeals court cases, decisions that are published, or Supreme Court case decisions, or some other possible statute that will affect how this is won. So this is these statements in here, not the law. This case is the law, and they have nice hot links here. Okay, I'm sure your state has something similar to that. These Court of Appeals, 93. Appeals, Supreme Court, Supreme Court, Supreme Court. Here's an Attorney General opinion. Again, not a statute, not a law, but someone that the person, the I don't know who, the Secretary of State or who is it that compiles, Legislative Reference Bureau, I'm sure compiles this stuff here. Here are some learned treaties and so forth, okay? They don't look that new. This is an important piece of information because we're trying to look up what are basically the big amendments here. What are the big, the historical movements that are explaining to what are the problems that they're solving, what are they addressing, how, in other words, how do we get stuck with the ERD? That's, I would say, the question here. So, hold on. All right, yeah, that rabbit hole didn't end up very well. We'll note here, as we're going back up to history, there's a bunch of cases from 75, 75, then 79. It looks like the changes here, we've got a 77 change, 79, 81, 87, 91, 2007, and 2009. So I think we'll probably go back to and see what we can see here. Oh, sometimes this can be really hard to find, so we'll pause for a second and go through this. This is basically, it's a lot better than what you used to have because you have to send away for it. But it will have the original law, and then it'll have what's changed, what's added, or what's removed. All right, hold on. Let me find it. All right, that isn't that hard here. So this underline here means that they're adding arrest record and conviction record, arrest record and conviction record. This is 77. They're adding definitions for statute. They're creating a new section 5H that defines arrest record. All right, let's see what else we got. Within the meaning of this section. Of a crime. Okay, they changed that. This is basically getting it so that people who've been arrested can get jobs, in theory. Felony, conviction of a felony. Got it. Got it. All right, let's keep going. So that's the 77 one. Let's see what they do in 1979. Section is, they add a new section here. 1131.4, the practice of requiring employees to submit to honesty tests, department to administer. Well, this is important. The statute is amended to read 1133. The department is to administrate. There we go. Except as provided under subunit 2, this subchapter shall be administered by the department. That's the Department of Workforce Development. The department may make, amend, and rescind such rules as are necessary to carry out this subchapter. The department or the commission may make by such agents or agencies as its designees to yada, 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 yada. Okay. So just more unfair honesty testing, no polygraphs. Got it. All right. All right, here we are. This is the 300-day rule here is 111.39 powers and duties of department, which is what brought us here. And it says, 1, the department may receive or investigate a complaint charging discrimination, discriminatory practices, unfair, yada, yada, yada. If the complaint is filed with the department no more than 300 days after the alleged discrimination, unfair honesty testing, or unfair genetic testing occurred, the department may give publicity to the findings of its case. All right, so let's figure out where this 300 days came from. History, 1973. Let's check it out. Okay, here's what we were talking about in this last case here where they add back pay. Bam. All right, we'll go back. 73. Why do we care about this? This is going to tell us where, what basically case or cases to look for that led us to get to this 3. Because remember, the last case we were at, it was 6 years. So let's find out. Oh, this is the danger of them. Sometimes they're really long and talk about chaplains for 30 minutes. Hold on. Bam. And it's just that easy. On page 242 of 451 on the 1977 amendment, which makes sense if you look at our case, it says the department may receive and investigate a complaint or charging a violation of this section if the complaint is filed with the department no more than 300 days after the alleged discrimination occurred. Bam. Now it says a complaint shall be a written statement of the essential facts constituting the discrimination charged and shall be verified. Sounds good. Haha, here's where we get this new section here, probable cause. If the department finds probable cause to believe that any discrimination has been or is being committed in violation of this section, it may endeavor. Okay, so this already existed because it's amended. But this one here, 1224C, let's check. That's our next question is when did this come into being? So we'll go back there. Oops. So, of course, the probable cause, no probable cause determination is not in the statute, although we saw it in the statute before. Remember, it was like 77, 79 that it came in there, this part 11, 3.1 here, the department to administer. So they made it now. Remember, this is the question of when did it shift over to become administrative law? I mean, it says 77, 75. That's what we looked at here. I think 77. Is that when the 300 days came in, or was that 79? Let's just check. Because then the question all points back to what happened in 1979 that made them create this scheme. Hold on. 300. You got to be kidding me. All right, so apparently in 1975, they added this department to administer. Okay, so if we look back to that department to administer, it also says cross-reference. Here, see also chapter DWD 218. We know that one pretty well. Fair employment, initial investigations, and probable cause, no probable cause. Bam. Initial determination. Okay, so let's look at this section here. Register 95. Well, let's see what happened in 95. I can barely believe this, but I remember doing this in law school here. So we're going to go to 95. It's going to take, this is just what was published in 95 on 474B. And we'll go to the final clearinghouse here. And luckily, they're all by at least, oh, it's not, it won't be DWD at that point. It probably will be this guy. Industry, labor, and industry, labor, and human relations. Okay. Equal opportunities and employment. Here's when they made these rules. They promulgated them on the 1695 Order of Adoption. Okay. Here we go. This proposed rule repeals and recreates Section 88, Wisconsin Admin Code, as yada, 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 which interprets the statutes here and promulgates these rules as follows. Okay, so we're going to have to go back at least to 88 here. The rules provide the decisions as are appealable to the labor community only when the division has made a final decision in this case. A final decision is one of which disposes of the entire complaint and leaves no further proceedings that the complaint pending before the division. Yeah, that's a really bad rule. Really bad rule. It allows the judges to just throw things into the mix and see what happens. We'll keep going here. Look at this. Administrative law judge, here we go. All right, well, we're getting there. Now I think we just got to go back to 88 and see what happens then. Yeah, that only took like half an hour, but what the heck? For you guys, anything. Okay, 45 minutes. Hold on. Let's look at this whole thing here. This is 1985. This is a rules-making certificate that's certifying the Secretary of the Department of, Industry, Labor, and Human Relations is certifying that they put this rules forth in the proper way and that nobody objected or whatever, and then here we're adopting it. For those of you who are interested in the administrative state, this is what we're looking at. The administrative state is born. All right. Boom. Here we go. Now, this is what I find astonishing. Fair employment practices, no improbable cause, MPC hearing procedures. Well, let's do it. Let's just do it. This rule is a revision of former IND 88, yada, yada, which became effective, which provided for hearings on the merits following initial determinations of no probable cause. That is not what we have today. We have this whole bifurcated thing where you get a no probable cause and then you get a probable cause hearing, which is a no probable cause is a much lower standard. Okay. The court in Milwaukee Board of School Directors v. State of Wisconsin, Dane County, held this rule violated and this is what it says: Dane County Circuit Court, but what I have is a federal court case on that. So let's make sure we have the same thing here. Held, and this it just would be astonishing that a circuit court case would, or even a district court case, would held that the rule violated some other statute, necessitating an emergency rule to conform agency rules with the court's decision. So they screwed up and went further than what they were allowed to do, or just didn't figure it out right. And then the court had to tell them, and then they emergency changed the rules on just a court decision. I mean, I guess if they knew that they had violated the, that's not how they would act today. For sure, that's not how they would act today. All right, necessitating, you see that there? All right, so let's just see if we can find that. The proposed rule would change the hearing from one on the merits to one on no probable cause. So this is the birth of the no probable cause hearing. All right, it only took 2 hours now. Man, what's an afternoon? Well, here we are. August 26th, 1965, it passes. An act amended and created denying employment opportunities and discriminating against, this is, I guess, the handicapped people. That is added in 1965. We're getting there, people. We are getting there. All right, here we're wrapping it up. I finally found it here. 1945, subchapter 2 of chapter 111, Fair Employment, Declaration of Policy. Here we go. This is the beginnings of the Wisconsin Fair Employment Act. And I've got a final little thesis here to share with you. All right, Declaration of Policy, the practice of denying employment and other opportunities to and discriminated against properly qualified persons because of their race, creed, color, etc., national origin, is likely to foment domestic strife and unrest and substantially and adversely affect the general welfare of the state, depriving it of the fullest utilization of its capabilities for production. Okay? Now, we talked earlier about the palliative remedy that the ERD poses and how that, among other things, could, is an analogy here. But I just want to round that up because I want to know what foment of domestic strife they're talking about. The denial by some employers and labor unions, yada, 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 tends to deprive victims, we read that before, of the earnings which are necessary to maintain a just and decent standard of living, thereby committing a grave injury to them. Number 2, it is believed by many students of the problem that the protection by law of the rights of all people to obtain gainful employment and other privileges free from discrimination because of race, creed, color, national origin, or ancestry would remove certain recognized sources of strife and unrest and encourage the full utilization of the productive resources of the state to the benefit of the state, the family, and all the people of the state. And so look here, let's look when this is written, approved July 17, 1945, published pretty quickly thereafter, July 25th, 1945. I'd like to compare the published dates on other things, but so that's their 3 days into the atomic age there. I don't think that's so much the reason for this, as I think this chart probably better explains it here. Because the question is, what riot, what foment are they talking about? And here, 1942, 43 Beaumont race riots in wartime tensions, overcrowded cities, which have been flooded by workers from the South, white workers from the Pennsylvania shipyard in Beaumont attacking a black man who had supposedly whistled at a white lady. Zoot Suit riots. All right, involving American servicemen stationed in Southern California and young Latino and Mexican-American city residents. It was one of the dozen wartime industrial cities. Let's keep going. of the dozen wartime industrial cities that suffered race-related riots in the summer of 1943, along with Mobile, Alabama, Beaumont, Texas, Detroit, Michigan, and New York City. So that's pretty, we got a war to win here. We can't have this kind of issue. I remember on Jack Benny, which is about this time when there starts sticking up for race relations. So just when we're talking about ham sandwiches and fighting and standing up for, the rights and not denying the rights that have been hard won, I think we need to understand what kind of milieu this law is coming out of here. It's, I think, very expressly in reaction to riots, race riots in manufacturing areas related to wartime production. Seems pretty clear that's what this law here is entirely designed to acknowledge. I mean, these statements here about fomenting riots and so forth here, I think that's the key. There we go. I think that says it all. Okay? So I'm going to wrap it up here, but I think it's important to understand and remember, there's a lot of people struggled during World War II, and many of them at home in factories. And many of those situations really highlighted and exacerbated the race tensions here. And I think that it's fair to say that people weren't going to fight for this country and suffer discrimination in the same way they weren't going to work for this country, making tanks, for example, and suffer discrimination. So I think that was all born out of people asking for more. So there we are. That's a little history lesson. I think we're going to get a lot more into the subject, but here we are. Take care. Oh, we can do this, right? We can.